Good afternoon, everybody, and welcome to our Wednesday webinar. Burkitt Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. I'm Helena Oxley, an employment solicitor here at Burkitt Long, and I'm joined by my colleague, Rianna Billington, who has today qualified as a solicitor. Rianna has been part of our Burkitt Long Human Resources and Employment team for a while now, and we're really pleased that she is remaining with us as an employment solicitor. So welcome. So today we are going to be looking at some, next slide please. I've just quickly mentioned this to everybody. So just to let you know, the information in this presentation is for legal purposes only and does not constitute legal advice. And this information is correct as at the 1st of December 2021 and is subject to legislative changes. Thanks very much. Next slide, please. So today we're going to be having a look at all the important legal updates in the employment world. And then Rianna and I will also be having a look at a case review. We've both picked a case each to run through with you. Next slide, please. So just before I have a look at some updates with you, we will be taking questions at the end, so please do make use of the Q&A facilities as we go through. So on the screen now you can see a number of legal updates that Rianna and I are going to run through, and I'm just going to start with vaccinations first. So as I'm sure you'll all be aware, mandatory vaccinations for care homes came into force on the 11th of November 2021, and this meant that regulated care homes in England had to ensure that no people enter care homes unless they can provide evidence that they are either fully vaccinated or that they are exempt. And with regard to boosters, although these are not mandatory at present, employers are encouraged to recommend and encourage those eligible workers to uptake the booster. Currently, we have a temporary self-certification procedure for those who are exempt, but this ends on the 24th of December. So just to note for any workers or employees, if you are yourself or if you have employees or workers that are exempt, they will need to, from the 25th of December, use the NHS COVID pass in the same way as fully vaccinated individuals. On the 9th of September, a consultation was launched to consider whether mandatory vaccinations should be extended to the health and wider social care sector, and this consultation ended on the 22nd of October. And on the 9th of November, the response was published, and it was decided that mandatory vaccinations should be extended to the health and wider social care sector. This will mean that providers of CQC regulated activities in the health and social care sector must only deploy individuals who have been fully vaccinated against COVID-19 to roles where they have direct face-to-face contact with patients and service users. The amending regulations will be coming into force from the 1st of April 2022. There is a 12-week grace period which will allow employers and workers some time to be ready to implement those provisions. There will be operational guidance which will help with facilitation, and once this comes out, Burkitt Long, myself and Rianna likely will do an update to kind of keep you all aware of what's happening. And just to be aware that mandatory vaccinations for the health and wider social care sector will apply to frontline workers, but it will also apply to some non-clinical workers who are not directly involved in patient care, and this will include receptionists, ward clerks, porters and cleaners. So there are many sectors that mandatory vaccination is not a requirement for, and the advice remains for these sectors that vaccination is encouraged as opposed to enforced. We have been speaking with a number of clients about this recently, so if you're looking into or thinking about having a mandatory vaccination policy and you're not in a sector where mandatory vaccinations are a thing, please do feel free to get into contact with us and we can talk to you about the parameters of that. I'm going to move on now to talking about the variant. So just a bit of a general update first. So the latest variant of COVID-19, which has been named Omicron, if I'm saying that correct, has led to increased restrictions in an effort to slow the spread of the virus. And these measures have been in place since yesterday, so the 30th of November. Guidance has been updated and these changes will be reviewed in 3 weeks' time. So the first thing to note, which I'm sure everybody will have been aware of if you've visited any shops since yesterday, is that face coverings have become mandatory again on public transport and in shops. The rules do not apply to other indoor venues such as gyms, theatres or cinemas, and they will also not be extended to hospitality venues for practical purposes. Those under 12 are exempt, and also there are those who cannot wear face coverings for medical reasons. So just to bear in mind that sometimes people won't be wearing masks and they will likely have a valid reason for doing that. Hopefully anyone else is abiding by the rules and will be wearing face coverings in the appropriate settings. And for people that are non-compliant, they could be fined for that. So just having a think about travel, the government has updated the red list of countries and people that are arriving in the UK from abroad will now also have to take a PCR test and self-isolate until they have received a negative result. With regard to contact tracing and isolation, there's not really any change there apart from one exception. So as before, close contacts of those who have tested positive for COVID-19 are encouraged to take a PCR test, but do not have to self-isolate unless they are over 18 and unvaccinated or if they test positive. But the exception to this rule now will apply to contacts of people who are confirmed or suspected to have contracted the Omicron variant. So those contacts will actually have to isolate for 10 days, regardless of vaccination status. Just having a think now about businesses and employers and the considerations for workplaces in response to this new variant. So businesses and employers should undertake a risk assessment to have a think about taking reasonable steps to manage risks to health and safety for their workforce and for customers. Businesses can require or they can encourage customers and their workforce to wear face coverings. Just to have a think when you're completing any risk assessment, that you do need to consider reasonable adjustments needed for staff and customers with disabilities. And if a business chooses to implement certain health and safety measures, it's important to consider carefully how that will fit in with the business's general health and safety duties, other obligations to staff and customers arising from employment rights and equality laws. And also all businesses should be following the principles that are set out in the Working Safely guidance. The Department for Education has also set out some new measures and there is some guidance for this. But just in brief, a couple of things to note is that these measures apply in early year settings, out of school settings, schools, colleges and universities. Our Head of Education, Thomas Emmett, has completed an article with some further details on this, and that can be found on the website. And if you'd like any support, whether that's to do with risk assessment or on anything to do with any updates that I've provided, vaccinations or variants, then please do feel free to get into contact with us. So face coverings for schools. So as of yesterday, the Department for Education is strongly advising that face coverings should be worn by staff and visitors to education institutions and by pupils in Year 7 or above in communal areas, of course, unless they are exempt. And also the fact that pupils in Year 7 or above are still expected to wear face coverings on public and school transport unless they are exempt. Testing, so in terms of testing, nothing's really changed. The Department of Education advises that educational institutions and settings should continue to encourage the use of lateral flow tests. Vaccinations, so all staff and students aged 12 and over are encouraged to take a COVID-19 vaccine. And with regard to international visits, it's advised by the Department for education, that educational institutions and settings should reconsider whether international visits are appropriate, considering the potential disruption caused to learning by the need to isolate and test upon a return to the United Kingdom. That's all of my updates. I'll pass over to Rianna now to discuss a few more with you.
Thank you. So I bring updates firstly on fire and rehire. There's been an update on this recently. ACAS has published some new guidance. If you aren't familiar with fire and rehire, it's a tactic that is sometimes used by employers when, for example, agreement can't be reached between them and an employee with regards to changing a term or terms in their employment contract. So essentially, if agreement can't be reached, an employer might decide that they dismiss the employee and then rehire them on the same employee, but under the new contract with the new terms as a means of getting that through. This was due to be debated in Parliament, and as at the 22nd of October, the bill was going to have its second reading, but ministers blocked the debate, if you like, and they said that whilst they opposed fire and rehire as a practice, legislation was not the way to deal with it, and they asked that ACAS produce some more comprehensive, clearer guidance to help employers explore the options before considering fire and rehire. So ACAS have now done this, and the guidance was published on the 12th of November. And essentially, the key messaging of the guidance is that fire and rehire is an extreme step, and employers should be exhausting all other options first, because it can carry a number of risks with it, such as potential legal claims for unfair dismissal, damaged morale and damage to working relations, because employees may feel that they're being threatened or forced to accept changes that they didn't really want to accept, potential strikes or industrial action, and also reputational damage. You may have seen there's been some there's been in the news some very negative reviews of companies like British Gas and Tesco who have tried to implement this fire and rehire, and it's not reflected very positively on them. So it's mostly for employers, the advice, but it does have a slight section for employees, and it reminds employees of their legal rights in these circumstances. So where employers are trying to make changes to terms and conditions, if they don't agree, what can be done in those circumstances? So it's for employees and employers. And our advice would be that whilst there's not going to be any specific penalty for non-compliance with this guidance, employment tribunals will likely have it in mind when they're weighing up any claim, so any claim for potential unfair dismissal. So best practice would be to follow it, and it needs to be after you've considered all the other alternative options first, because the tribunal is not going to look very kindly on you if you jump straight to fire and rehire and you haven't, exhausted the other options first. So if you do find yourself in a situation where fire and rehire is what you're going to proceed with, employers need to bear in mind that you need to have a fair reason for dismissal, because again, if you don't, that could increase the risk of unfair dismissal claims. A fair dismissal process then needs to be followed. You also need to make sure you're providing the correct amount of notice to employees to avoid any potential wrongful dismissal claims. And also you should be offering the employee a right of appeal against their dismissal. And as I said, if you fail to take any of these points into account, it could lead to a successful claim for unfair dismissal. So I've written a blog on this for our website if you want to read a little bit more. And also, as I said, the guidance is published. It was published in November, so it's up on the website if you want to take a look on the ACAS's website. So that's fire and rehire. Today, so 1st of December, the Making Flexible Working the Default consultation is going to close. So this is a consultation on flexible working, and it contains proposals to reform the flexible working regulations. And it's asking for views on issues like, should we potentially extend the right to request flexible working to all employees from day one? So should we make it a day one right? and that would obviously remove what's the current requirement now, which is that employees have to have 26 weeks continuous service to be able to request the right to work flexibly. Do note, however, that this doesn't mean that it's going to be an automatic right for employees from day one to work flexibly. It's just going to potentially give them the right to request to work flexibly. The consultation also asked for views on whether the 8 business reasons that are currently valid for refusing a flexible working request are still fit for purpose and still appropriate. And just to remind you, these business reasons that are you can currently reject a flexible working request on are if it's going to cost too much to implement the request, if you grant the request, you're not going to be able to reorganise the work amongst other staff, if you won't be able to recruit more staff, if there's likely to be a negative effect on the quality of the work, and if there's likely to be a negative effect on the business's ability to meet the customer demand. Also, if it's going to affect the employee's performance in granting the request. Another valid reason is that if there's not going to be enough work for the employee to do at the times they've requested to work, if it's the timings that they want to alter, etc. And also if there are already planned changes coming to the business. So, for example, if the employer plans to reorganise or change the business and thinks that the request won't fit in with these plans. So we await the response, and it's likely it's going to take some time for the results to come through. But good practice when dealing with flexible working requests as they currently are would be to ensure that, again, if you don't have a flexible working policy that outlines how employees should be raising their requests, then you should really be following the ACAS code of practice on how to handle flexible working requests. Again, utilising this because any employment tribunal would likely have regard to these provisions, especially when considering any claims from an employee that their employer has not dealt with their request in a reasonable manner. So broadly speaking, the code suggests that employers need to be discussing any requests with employees as soon as possible and allow them to attend the meeting. So hold a meeting after and allow them to attend with any accompanying colleague to discuss the request. Obviously, if you intend to grant the request without issue and without question, then a meeting is unlikely to be needed. Any requests that are received need to be considered carefully, and employers need to weigh up the benefits of the request for the employee and the company against any potential adverse impact, and also ensure that any decision is not discriminatory. That's really important. Women may benefit from greater protection here if a flexible working request is asked for because, you know, childcare responsibilities and duties, so do be careful with that. And also, any decision should then be communicated to the employee as soon as possible in writing, setting out clearly any grounds for rejection. And if you are rejecting, you should then allow the employee to appeal that decision. And the grounds need to be set out clearly. It's not enough just to state one of the reasons. It should really be a kind of process to show that you've thought about it and weighed it up, the positives and the negatives, and state that in the decision letter. Why is it also important to make sure that you're dealing with flexible working requests carefully? Because a recent study that's been conducted has found that refusing to accommodate flexible working requests is costing businesses £2 billion a year, which is a huge sum of money. And they've found that the cost, and this was a study conducted by a company called Flexonomics, and they attribute the cost to the link between flexible working and employee morale, boosted productivity and lower employee absence. So that's another important reason why you should be doing it. It can be costly not to properly look at these requests. Also from today, I just wanted to raise that the Employment Tribunal rules have been changed. So they've been changed to allow a prospective claimant to provide the names of more than one prospective respondent on an early conciliation form. The current position is that the claimant or their representative has to complete an early conciliation form for each respondent named. And you can imagine that it's not uncommon in litigation for there to be many respondents' names. So it's going to save a lot of time not having to name everyone and do a form individually for everyone. So we think it's going to save time and costs for those both completing the form and also for ACAS who process them. And we view it as a sensible and overdue amendment. And as I said, this decision or this change and the flexible working consultation both end today, and fire and rehire has been since November. So you can look at guidance if you want to. And that's it for our updates. So could we have the next slide, please? Thank you. So looking at some cases now in a little bit more depth and what we can learn from those.
Great. Thank you, Rianna. Okay, so I have chosen the case of Gray and the University of Portsmouth. So just to give you the case facts first here. So the claimant was employed by Portsmouth University, who is the respondent in this case, as a service delivery analyst in its information service department. The claimant had worked with the respondent since 2009, and there had been no issues until 2014. As a result of a health issue, which was unrelated to his work, the claimant took some 3 months off on sick leave, and the claimant was also diagnosed with high-functioning autism in the same year. After the claimant's return in October 2014, he was involved in an incident that led to a breakdown in his relationship with his manager. The respondent attempted to rectify the situation by organising a facilitated meeting, but this was unsuccessful as the claimant was unable or unwilling to engage in the process. The claimant went on sick leave again, and after a lengthy period of sickness absence related to his disability, which was stress combined with this diagnosis of autism, the claimant was dismissed from his position. So he did appeal the dismissal decision, however, this was rejected. The claimant then went on to bring a claim for discrimination arising from disability under Section 15 of the Equality Act 2010. Rejecting his complaint, the tribunal held that the claimant's dismissal was a proportionate means of achieving a legitimate aim, and the legitimate aim here being the efficient running of the department. The claimant then appealed to the Employment Appeal Tribunal, and the appeal concerned the approach to be adopted by a tribunal when considering the question of objective justification in a claim brought under Section 15 of the Equality Act 2010. The EAT here, so the Employment Appeal Tribunal, held the tribunal is required to carry out a critical evaluation of the respondent's justification. And the tribunal must also demonstrate in its reasons that it has done so. The ET referred to the position as obvious. However, that was not demonstrated by the ET's reasoning in this case. The EAT also went on to say that it was not enough for the tribunal to find that keeping the claimant's job open would be significantly disruptive to the respondent without explaining why that was the case. The EAT also said that the evidence put forward by the respondent provided a number of potential explanations as to why the claimant's dismissal was a proportionate measure, but it felt that the tribunal did not make clear in its reasons which explanation it truly accepted. Further, the EAT held that the tribunal also did not make any findings about the level of disruption caused by the claimant's absence, nor about how his role was covered during the absence. Therefore, the EAT decided that the appeal should be allowed, and the case was remitted back to the same employment tribunal to carry out the necessary evaluation. So that case really was about the employment tribunal not dissecting and detailing its reasoning in the written decision, the written judgment. But there are a couple of important things I think that can be taken from this case. So the first thing is to kind of have a look at objective justification from the perspective of long-term sickness absence. So that's why here on the slide for you now, we're going to have a quick look at this, a proportionate means of achieving a legitimate aim, which I'm sure most employers will have come across at some point. So under Section 15 of the Equality Act 2010, discrimination arising from disability is subject to the standard objective justification defence test, which is that unfavourable treatment in question, the unfavourable treatment in question must be a proportionate means of achieving a legitimate aim. So the Employment Tribunal in the case Gray and University of Portsmouth did specifically refer to the 4-point guidance that was provided by the EAT in another case detailed on the slide, McCullough v ICI in 2008. So here it was summarised that there were 4, as we've said here, the 4-point guidance. So one being that the burden of proof is on the respondent. So if you're an employer client, an employer who is a respondent and potentially a client of ours, it's just to be aware of the fact that the burden of proof will be on you to establish justification. So that's just something to be aware of and to have a think about during any process of sickness absence. And it's important to be aware of that from the start. 2, that the tribunal must be satisfied that the measures must correspond to a real need, are proportionate with a view to achieving the objectives pursued, and are reasonably necessary to that end. 3, that the principle of proportionality requires an objective balance to be struck between the discriminatory effect of the measure and the needs of the undertaking. And the more serious the adverse impact, the more cogent must be the justification for it. And 4th, that it is for the tribunal to weigh the reasonable needs of the undertaking against the discriminatory effect of the employer's measure and to make its own assessment of whether the former outweighs the latter. So the takeaway from here is that as an employer, like I'm saying, dealing with any kind of sickness absence situation, it's important to take note of this test. During the process, take the time to consider and note some details, because as this case demonstrates, there are a number of things the tribunal need to be looking at when they are considering a case. And for that reason, if an employer knows from the outset of any kind of sickness absence case that they have ongoing, you can prepare yourself. So think about these things as you go along, and make sure it's part of the decision-making process and you take notes. Because if you receive an unexpected or anticipated claim, your memory recall will be much better if you've got some detailed notes that you took at the time that all of these things were ongoing. So having a think about, what's our legitimate aim going to be from the start and what are the needs of the business. So some details that the EAT said that the ET did not collate were, for example, and these are things that you should have a think about when going through this process. So the level of disruption caused by the employee's absence, that's something that you can have a look at that department and ask yourself that question and note down the issues that are being experienced rather than just experiencing them. Really have them noted down with dates. How the role will be covered, so who's going to be covering the role, or is there a gap there and you're having a serious issue covering it in their absence. Also establishing the level of the need for that role, any additional costs in needing to cover it for that period. It's all something that happens at the time, but it might be useful if organisations have a list that when a sickness absence case is upcoming, you have a list that you can refer to, that you can jot notes down for that, so that if you need to return to it in the future, you've got something there to better protect yourself. So some further points that I've taken from this case are kind of just best practice. So in the case, the tribunal noted that the respondent employer was accommodating to the claimant. So there was no criticism of the policy, and it noted that it followed its own company policy. Often, sometimes the policy isn't followed, and that is an easy criticism. And also, is your policy up to scratch? Have you had it reviewed recently? Just little things that you can do to protect the business from the start. Other things that this employer did that was demonstrated in the case and noted by the tribunal are, for example, with meetings, they were frequently delayed or rescheduled to accommodate the claimant. reasonable adjustments were made. So, for example, they allowed him to be accompanied by someone who wasn't a colleague or a trade union representative. The Respondent also organised occupational health appointments for the claimant. They provided support to him throughout this period of sickness absence. And they also offered him support internally, and they made inquiries for him externally to relevant and appropriate organisations. So I think it's really just about considering what you can do within reason to be able to demonstrate that you have accommodated the needs of a particular individual. But like I say, it's got to be within reason, what's appropriate and realistic for the business. And it's just points that could really help to support you if unfortunately a case is brought, but at least you know you've best protected yourself from the start. So that's my case review. I'll pass you over to Rianna now. So please can we have the next slide?
Lovely, thank you. So I'm going to be talking about the recent case of Hovis Limited and Loughton. I'm going to be talking about, we're going to talk a little bit about the tribunal's judgment at first instance, and then there was an appeal, and the recent judgment is the appeal tribunal judgment. So just to give a bit of background, the claimant worked for Hovis as a delivery lorry driver, and on a night in December, a manager of Hovis reported that whilst he was driving his car on the motorway with his wife in the passenger seat, both of them saw the claimant driving his van, his Hovis van, on the same stretch of motorway, and he was smoking at the wheel. So the manager of Hovis obviously raised this with his higher ups, and there was an internal disciplinary investigation and a process was undertaken, and the result of that was that the claimant was found to have been smoking whilst driving, which was a serious breach of Hovis's procedures, and so he was dismissed without notice. So he was summarily dismissed. He brought a claim for wrongful dismissal and unfair dismissal to the Employment Tribunal. And at the first instance hearing, the claimant himself gave evidence in person and denied that he'd ever been smoking in his van, but the manager and the manager's wife didn't give any oral evidence to the tribunal, so they didn't hear from the first-hand witnesses themselves. The result at first instance was that Mr. Loughton was found to have not been unfairly dismissed, but the tribunal did uphold his claim for wrongful dismissal, so found that he had been wrongfully dismissed. Just to kind of talk about the two dismissals very quickly, a claim of wrongful dismissal is a type of breach of contract claim, and it can be heard either in the Employment Tribunal or in a county court or the High Court. And as a cause of action itself, it doesn't actually arise from statute, but it arises from common law, and claims to do with it are usually because of notice pay or notice and failure to give proper notice or not give notice pay, as was the case with Mr. Loughton. He was dismissed without notice, and he was arguing that that was wrong. Unfair dismissal, on the other hand, is when an employee feels they have been unfairly dismissed, so not for one of the 5 fair reasons, and also potentially if an unfair procedure was followed. The distinction is that there's no use for the range of reasonable responses test, which is used in unfair dismissal claims. So that asks, was dismissal within the range of reasonable responses, and was the employer right to do that? Was it reasonable to dismiss? For wrongful dismissal, the facts are looked at, and the facts which are being alleged must be proved on a balance of probabilities by evidence. And this evidence is brought by the party who bears the burden of proving that the facts are true. So in this case, it would obviously be the respondent proving that the claimant was smoking in his van. It doesn't matter whether somebody acted reasonably in believing whether the fact was true. That's irrelevant to the exercise of wrongful dismissal. So bear that in mind, and also bear in mind that when you're defending a claim for unfair dismissal, usually there are 3 key witnesses, being the investigator, the decision maker, and the appeal decision maker. But the difference with wrongful dismissal is that none of these witnesses are likely to have been able to provide direct evidence in respect of any acts of gross misconduct, which then led the employer to dismiss the employee. So it's likely to be reliant on hearsay evidence. So also bear that in mind. At first instance, the tribunal judge said that, the employer had not called anyone who was an actual witness to the events on the night in December, and there were only 3 people present when the incident occurred, and that was obviously the claimant, Mr. Loughton, his manager, and his wife. Mr. Loughton had given oral evidence and had been cross-examined, but as I mentioned, the employment judge didn't hear from either the manager or his wife, who were the only other individuals who would have been able to provide a first-hand account of the incident. So on that basis, the employment judge felt that because she was unable to evaluate the evidence of the only other first-hand witnesses to the matter, she could make no finding of fact about whether Mr. Loughton was smoking or not, as was alleged by his employer. So she found in his favour, and she found that he had been wrongfully dismissed. The Hovis didn't agree with that, obviously, and they appealed the decision. They brought it to the appeal tribunal, and the appeal tribunal held that the first instance tribunal and the judge should have sought to evaluate hearsay evidence of the statements that had been gathered by other witnesses and also considered as part of the disciplinary process. So people like the investigator, the decision maker, and the appeal decision maker, they were obviously basing their views on what they'd heard from the manager and his wife. And the employment appeal tribunal said that they should have looked at that evidence and based it on that. And the employment appeal judge highlighted Rule 41 of the Employment Tribunal rules, which you can see on screen there. This provides that employment tribunals are not bound by any rule of law relating to the admissibility of evidence in proceedings before the court. So some courts, obviously hearsay is not admissible, but the tribunal is able to hear it. Obviously they would prefer first-hand evidence, but hearsay evidence is admissible. So the judge went on to explain this in his judgment, and he said that what Rule 41 means in practice is that hearsay or documentary evidence or other types of evidence of whatever nature are not as such inadmissible, and if such evidence is sufficiently relevant to what the tribunal has to decide, then it should be considered. And then it will be up to the tribunal to assess the evidence and to decide what weight to attach to it. So because of that, the judge allowed the appeal and he remitted the matter back to a different employment tribunal. He reached this decision because he said that the initial employment judge, in concluding that she couldn't make a finding of fact as to whether Mr. Loughton was smoking without hearing the first-hand evidence of the manager and his wife, was actually an error of law. So what can we take away from this case? Well, I'm not sort of suggesting that this judgment promotes the use of hearsay evidence in wrongful dismissal claims, because it makes clear that, as I said, first-hand evidence is always going to be preferable, but this decision does make it clear that an employment judge can consider such evidence, and having done so, give the evidence its appropriate weight in the context of all the evidence in the case, particularly when considering whether the alleged acts of gross misconduct occurred or not. So where there is a claim for wrongful dismissal, every effort should be made, as I said, to lead first-hand evidence from those who witnessed the acts of gross misconduct. But this decision does show in cases where it's not possible, it's clear an employer can and should lead to rely on hearsay evidence. It's then up to the employment tribunal to decide whether that evidence, along with any other evidence in the case, is sufficient to prove on a balance of probabilities that the dismissal was not wrongful. But I suppose this judgment shows that not all is lost if you haven't got that first-hand evidence from your witnesses. It was probably a mistake on the behalf of the respondent in not allowing the manager and his wife to be cross-examined at the tribunal, but it proves that not all's lost and hearsay evidence can be relied on in cases such as these. preferably first-hand evidence, but if it's not an option, hearsay evidence will be admissible in the tribunal. So that was the case I wanted to have a little chat about. I did have another one prepared, but I wanted to leave enough time for questions. So I think we've got 4 at the moment. Perhaps what we can do is take a look at them, the questions, and then if any more come in, we'll answer them. If not, we can perhaps talk about the other case, but they look like there's some interesting ones coming in, so we can
Great.
We can deal with those and see what happens.
Yeah, thank you. Okay, so just before we take questions, just to let you know that a recording will be sent out to you of this webinar tomorrow morning, and some notes will follow shortly after, within a few days. Also, you'll see on screen there that we've got a link to a very short survey. We'd really appreciate if you could fill this in so that we can make sure that future webinars are helpful for you. As we said at the start, this is one of a series of Wednesday webinars. Our next one is Burkitt Long's approach to corporate social responsibility for business owners and directors, and that is on the 15th of December. So if you're interested in this or many others that we've got coming up, and you can see them on the screen now, please do go onto our website, or you can go on our Eventbrite page to sign up. But yeah, so that's everything for now, and we'd be happy to take questions.
Thank you both. The first question we have is from Stephen. Unions have pushed back to say we can't run individual consultations until collective consultation has finished. We have agreed but not convinced they cannot be run in parallel. Appreciate the legal position on this. ACAS say there may be situations where can run concurrently. Do we really have to wait for collective consultation to finish first?
Thank you, Sarah. Right, so I'll give it a go first. So I think without knowing the reason why the unions have pushed back to say you can't, as you've identified, the legal standpoint is there may be situations where you can run them concurrently. So arguably that's your first point is, if they're saying you can't, well, technically you can, and it really depends on their reasons for saying why they're suggesting not to do that, and your reasons as to why you feel like it's beneficial to do them at the same time. And I think if we think back to the case that I've just discussed, it's really about being able to show that you've considered things and gone through a process and taken notes. So I think it would be to consider, okay, so this is what the unions have said as to why they say we should wait. The position and following ACAS guidance is something you'd need to be able to demonstrate to the tribunal. So you can say we considered that ACAS said there may be situations, and they put it broadly like that because it really depends on the situation. So I think it's for a business to take a decision as to, we consider that this is one of those situations because, and then you could say we felt that it would benefit those individuals if we had it concurrently. So I think the short answer is, without knowing the reasons, no, you don't have to wait, but it's for you to be able to justify why you think that it's beneficial to not wait and it's beneficial to do those two activities concurrently.
Yeah, it's like the same sort of thing as saying, everything's dealt with on a case-by-case basis. And again, as Helena said, ACAS have worded that quite widely because it will be up to you to kind of take a view, and an employment tribunal would look at everything on a case-by-case basis. So again, it's about attaching or sort of going through the reasons as to why you think it should be running concurrently, and hearing the trade union's reasons as to why it's not, and coming to some sort of view or agreement there, I would say.
Yeah.
Thank you very much. The next question we have is from Liz. We have had an informal query about compressed hours, working full-time hours in 4 days rather than 5. I'm not keen on this as a plan, as this means that people will be working over 9 hours a day with lunch and breaks. This means over 10-hour day, which is not great for health and well-being. Would this be a good business reason to not go for this type of flexible working request?
So I think that's also partly why I was trying to sort of think what business reason, what out of the 8 business reasons, which would you be able to kind of rely upon there? And I suppose you would potentially be able to rely upon if granting the flexible working request would have a negative impact on performance due to, you know, like you said, health and well-being potentially being compromised. And I think that's part of the reason why the consultation's ongoing, because it's in those business reasons, is there enough to cover situations such as these? So I would say, again, it needs to be weighing up the benefits for the employees and weighing up the potential benefits for the business, and also contrasting that with any potential adverse impacts, which, as you've kind of raised, is likely to be health and well-being and a potential impact on that. I would say as well, query why they want the compressed hours. Again, if it's anything that potentially might that might have protection due to a protected characteristic, consideration needs to be taken there to check that you're not, you know, in then refusing the flexible working request, you aren't going to expose yourself to any potential discrimination claims. I think, as I said, I think negative impact on performance might be the one, but again, it's not really going to be appropriate just to kind of pigeonhole it into fit. You really do need to consider the benefits and, you know, the negatives, and then come to a reasoned decision and make sure you're expressing that clearly to the employees if you do refuse the request.
Yeah.
Have you got anything to add on that?
Yeah, I think those are the pointers, aren't they, really, is likely to be performance when it comes to the whole health, you know, your health and well-being. Also, as Rianna said, really important to just ask the questions around why they're asking for that, as Rianna said, discriminatory issues there. Just something I've noticed at the start of that question, it says that there's an informal query, and at the end we talk about the flexible working request. So for Rianna's done a lot on webinars to do with flexible working requests, but you know, is a formal request that's a statutory right, and when making that request, you know, they usually have to say, you know, I'm exercising my statutory right to make a flexible working request, and a certain wording that has to be used. So if it's not that and it's an informal query, you can treat it informally first, and you know, because you kind of want to clarify, you know, is this informal? If it's informal, let's follow an informal process, and then if they know their rights around this, they then might make a flexible working request. But I think just kind of keep that in your locker for now if it's not a formal flexible working request, and you can just discuss informally the fact that you're concerned about their health and well-being. So can you find out a bit more about why it is that they are looking into that? And if it's not, you know, the formal flexible working request, you can say we're concerned about your health and well-being, and that's fine. You don't have to have a look at the rigid 8 options for rejecting. You could actually say something that's a little bit more tailored to the truth, you could say.
And that might stop, you know, them bringing the request, depending on how that goes.
Exactly.
But obviously they may well exercise their right to do so. Okay.
Liz has just come back to say that they were wanting to help look after their baby with their partner, the reason for requesting.
Yeah, this is the tricky topics are around childcare and that kind of thing. So I think it's about balancing. Okay, so but it's also not to be scared, because I think one thing for employers is certain things are raised and you get a little bit worried. We had the recent case, again, Rianna's done an article on it. Can't remember the name of it right now. Sorry, it's probably escaped you as well, but yeah, and that, you know, that lady did a flexible working request, and that was to do with childcare, and and she actually, you know, the employer rejected it. They didn't handle it very well though, and so she won her claim against them for that. But you know, it wasn't necessarily because it was about childcare, it's because they didn't handle it well. But the point is, it is a topic that's worthy of serious consideration. So I think, yeah, I think if it's informal, just having that conversation, seeing if there's other workarounds. But what we usually do is say to go back with a suggestion of something that could work for the business and potentially for them. So you can say we consider that, we're a bit concerned about your health and well-being, and especially if it's to look after a baby, you don't want this individual to exhaust herself over these 4 days. But at the same time, I'm saying we have to be flexible. So I think it's about potentially could a drop in hours, if it's the 4 days is important, could there be a drop in hours to make that work temporarily to see how that goes. And another thing we recommend is perhaps having a think about doing a trial temporary basis of a new routine to see how that works, so you can kind of work together on things.
Cases Thompson and Scran Crown Limited as well, if you're interested. It was in the news. It's an estate agent. She won a large sum of money, so you may well have seen it, but it has important learning points on flexible working requests, and particularly in light of childcare responsibilities.
Great, thank you very much. Next question we have is, what is the position when a term time only employee has booked a foreign holiday prior to the latest government announcements? They now will need to have a PCR and self-isolate on their return to the UK, therefore be unable to join when the school reopens until they receive a negative test result.
Yeah, that's a difficult one, isn't it? Because it's just kind of come into fruition now.
Well, I think so. The guidance has said reconsider travel because of the change in restrictions. So I think perhaps initially having a conversation with that person, it has to be, not pressured or anything, obviously not suggesting that's something that you would do, but you might have had a conversation already. That employee might already be having second thoughts about travelling anyway, because some people may be feeling that way inclined. But I think it's a bit of a difficult one. It depends on, is it possible for their role to be carried out at home for a couple of days? I think that's the first stance is, one, ascertain if they're still planning to go. Two, is it possible for their role to be carried out at home for that period? And I guess it's tricky because you don't know if they get back and it's a negative test and they're able to return sooner, that's okay. But if they get back and then they need to isolate for 10 days, that could be more of a problem.
Yeah, no, exactly. And I think unfortunately, at the end of the day, if they do decide to go, you would not want to be in the position where you're telling them to kind of breach the government guidelines either. So I guess once you've kind of ascertained, is it still their view to go, you might have to accept that the position is, if they are going, you're not really able to say, you need to come in any event. It does need to be potentially thinking about, can they do some work from home just while they are receiving, waiting for their test result. I think now you can get some rapid ones as well, so they're pretty much, you sort of take them and within a couple of hours you have the response. So just, I suppose, if they are deciding to go, it's going to be offering suggestions like that, but you won't be wanting to encourage them to break any rules, I would say. And
potentially if you've had a policy in place before previously, that talked about what happens if people do go on holiday and they have to isolate upon their return. Sometimes you have it might be unpaid leave, or kind of, I think it's an important time if you had a policy before and just to kind of re-invoke it or kind of keep going with that. And if you didn't, perhaps just setting out so that your employees are aware of, if you are going to be doing this is the way we're going to handle it. So I think it's just, if you are planning to perhaps say, if you have to isolate, it's going to be unpaid leave from us. We could see before, there was certain things like you might receive sick pay or that kind of thing. We haven't got the full guidance yet. Like I said, that they will be providing that shortly, but I think it's just making sure what's the rules going to be for the school and making sure you get that out to employees as soon as possible.
Thank you. Next question is from Tiffany. How can you find out if a claim has been made against a company if the time limit has ended? Is there anywhere online to look up on ACAS certificate number?
I don't believe so. You can, any judgments that have been passed, you can look on the government website, you can type in the name of the company and you can see any judgments they've had against them prior to 2017, I believe. But I don't think you are able to find out if any claims have been made against a company, just if time limit has ended for after the early conciliation period, as far as I'm aware.
Not as far as I'm aware either.
Yeah,
I think it is tricky at the minute because of the delays in the courts as well. So before, once that time limit had ended, you know, you give yourself a month or so, and if you haven't had anything come through, then you feel like there's not a case hopefully brought against the company. But at the minute, the tribunals are so behind, sometimes we're not necessarily seeing things until a later period, so I think that's a tricky one. But I'll double check that, Tiffany, and if I can find something, then we will let you know.
Thank you. Next question from Jill. Are there any updates on proposals to strengthen legal protection against sexual harassment in the workplace?
I came across it briefly when kind of looking at what updates we were going to talk about. I think it comes under the umbrella of the government's Good Work Plan, which has been spoken about since 2018, and then doing an overhaul of the legislation and, like you said, strengthening proposals against sexual harassment in the workplace. I still think it's a little bit up in the air. There's no concrete date on any proposals yet. I certainly couldn't see any when I was doing my review. I think when I last read it was purported to be 2022 before we were going to get anything on that, but we can certainly have another look for you, and I'll jot that down if that is something that's of interest for any next kind of webinar or forum that we have, to make sure we cover it if and when details come out. I think that's all I can kind of say on that one.
Thank you. Next question we have is, can we say in an offer letter following satisfactory completion of probationary period, you will join the duty manager rota, having received training? Each duty manager shift carries an additional one-off payment of £20, or if they are receiving training for it, should they be paid a one-off payment of £20?
I'm just reading over one more time.
Yeah. So is the question, if they're, because of the training, should they be receiving a one-off payment of £20, or should each shift carry an additional one-off payment of £20?
I think it's kind of specific. It depends what the training is. Is that to kind of cover the training, or is that them? I'm not sure. It depends on what the requirements are there, to know if, you know, is there some kind of parameters around, are they supposed to be paid for it, is there a minimum, that kind of thing. If there isn't any minimum or kind of mandatory payments that needs to be made, then it's probably something that you can decide yourself.
Discretionary, yeah.
Is discretionary, although of course bear in mind what you have for your current managers as well, because you don't want there to be too much disparity between them, because that could cause potential future issues. So perhaps kind of marry that up to something you have in place already, or just consider that.
Thank you. And the last question that we have for today is, when is a flexible working request considered formal? Can the employer ask for the request to be in writing and consider a formal request?
Yes.
Yeah, I think if you feel it might be, it's a tricky one, isn't it? Because there are statutory requirements for it to be formal. So as an employer, you know those, you know, you can check with us if you'd like to know the requirements. You can look at it and, you know, has it got this, has it got that? And if it doesn't have the legal requirements, you could write it off and say it wasn't formal because it didn't have the requirements. So you could take a hard line on it. Arguably, we might advise to be a bit more cautious, and you could go back and and double check and say, you know, are we treating this as an informal request, or are you wanting us to treat this as a statutory flexible working request? If so, please can you provide it to us in the appropriate format, and then you could let them know what the statutory requirements are and then ask them to come back to you with that. So that's probably the safer way to deal with it.
Yeah, I think one off the top of my head is that it needs to be in writing. A formal request does need to be in writing. So again, that's part of it. If it's popped in an email, really clarifying, is this your formal request? And even going back and asking the employees, well, you know, the requirements state this, so make sure that they're tailoring the request just so it's clear to you, because you wouldn't want to treat it inappropriately. But yes, you can definitely ask for it to be. So say you're having an informal chat and it's getting to the point where, you know, you'll be able to tell, I suppose, but you can always turn around and say, OK, I've taken that informally. If you now want to make a formal request, you need to put it in writing, and you need to follow the kind of the statutory requirements just to make it crystal clear, I think. But yeah, I think clarity is going to be key. You just want to make sure that you're not misunderstanding anything and just dealing with them as reasonably as you can, I think is the key to it, isn't it, really?
Yeah. Okay, so I believe that's the last question, and it is 5:30 now, so we won't hold you any longer. But we'd just like to say thank you all very much for joining us today, and we hope that you found this useful. The couple of points we've noted, we'll have a look into those and go back to those individuals. If it's useful, we might be able to send it out to everybody. But yes, if you have any questions or need any help, please see our contact details on screen now. But otherwise, again, thanks for joining us and have a lovely evening.
Thank you very much.